Hello, my name is Jerry Spence. I'm the CARTA Hearings Director and Deputy Registrar. This is part two of continuing competency activity, and it involves hearings. So what happens after an investigation? If there's cause, we go to a hearing. This presentation is meant to describe a hearing to you so you understand what your rights and obligations are. I'll just share the screen here. Now, if you look, we're going to start with our learning objectives. We want to describe the hearing process pursuant to the Health Professions Act. We want to identify the hearing participants and define their roles. We want to identify the legal responsibilities and obligations related to the hearing process that a regulated member must fully comply with pursuant to the Act. Just as important, we want to identify the legal responsibilities and obligations related to the hearing process that the college must fully comply with pursuant to the Act. And then we'll talk at the end about appeals available to the member and the college. The learning activities that you have to do in this competency process are to identify the participants and their roles in a typical hearing, to look at this video, to read and comprehend the relevant sections regarding the hearings in the Health Professions Act. And these are included in the appendices of the written presentation that you'll be going through. You are going to pass an exam. That exam will consist of true, false, multiple choice, and multiple choice questions. So let's start with what starts a hearing. Well, obviously there's a complaint and investigation, but a hearing doesn't get started until a very specific document called a referral to hearing is sent to the hearings director. Once the hearings director gets that, he has 90 days to set the date. Here's who needs to get that. The investigated person will be given a notice to attend with reasonable particulars. I will advise the complainant of the date and time and location of the hearing, and I will also let any witnesses give them notice to attend or produce. Hearings are always open to the public unless they're closed, and a petition must be made to the tribunal to close them. If you look, the hearing starts with opening remarks, introductions by the tribunal chair. Then the prosecution or CARTA presents their evidence. After CARTA makes its case, and they would call their witnesses, and the investigated person presents their defense, they would call their witnesses, they would be cross-examined, and the tribunal can also question at any time anyone in the room who they think would have something to add. There's closing remarks, and the tribunal creates a written decision. Often what they'll do, especially if there's an agreed statement of facts, is they'll issue an oral decision at the end of the hearing before the written decision comes out. If there's possible criminal conduct, then the tribunal would order the hearings director to refer the matter to the Minister of Justice and the Solicitor General. So a couple things we need to talk about here is the burden of proof. The burden of proof in a criminal investigation or hearing is beyond a reasonable doubt. The burden of proof in an administrative hearing like CARTA's runs is much lower. So if CARTA wants to see a judgment in favor, they have to be able to show that a particular fact or event was more likely than not to have occurred. In other words, if it's 51% for the CARTA, then CARTA gets the decision it wants. If it's not 51%, then it is in favor of the investigated person. The tribunal can't have ties. It has to choose one or the other. If you look in this hearing, witnesses are sworn. So someone to tell a falsehood would be perjury. Witnesses give testimony and they can be cross-examined. Questions can be asked by the tribunal, and it's a lot less formal than a courtroom. So no one's going to go objection or whatever. People talk, and the tribunal will listen to concerns. They'll leave the room for a few minutes. They'll come back. They'll have a decision. So at the end of the hearing, a tribunal issues a written decision. That decision is about whether or not unprofessional conduct occurred or didn't occur. If unprofessional conduct occurred, then you can see here, they're going to have to give orders in their decision. And orders are things or directives to the investigative investigative person that they must comply with. They can also add costs to their decision. For instance, 50% of the investigation costs, 50% of the hearings costs. There is a table that they can use to help themselves set up. Often the cost can exceed $10,000 and can be very high. And also they can issue a fine if they feel that the behavior was really egregious and they want to deter it. No, they write a decision and none of those things are done, but it's important to note that if someone gets a decision they're not happy with, it's not the end. Either party can appeal within 30 days to the hearings director in writing. So let's look at who is in a typical hearing. Well, the first person would be the respondent or the investigative person. This is a regulated member who's been investigated for unprofessional conduct, and now we're having a hearing. Often they're represented by counsel. There's the complaints director. They're the person who did participate in the complaints and investigation process, and they act as a prosecutor, or they have a counsel who will act as a prosecutor in their place. There's the hearings director, again appointed by counsel. The hearings director has to be away from the nitty-gritty. They don't participate in hearing reviews or appeals, although appeals are sent to them, and they don't participate in the complaints and investigation process. The first thing the hearings director knows about those things is when they get a referral to hearing and the reasonable particulars in the notice of hearing. There's the tribunal members. Their job is to decide the case. Right now, a panel consists of 3 members. 2 are professional, who are appointed by counsel, and 1 are public. The professional members get significant training in administrative justice. They take courses from the Foundation of Administrative Justice, and there's also a CARTA run course they have to do before they can be appointed to a tribunal. They also have to sit in on one hearing, so they actually get some practical experience. They may or may not have counsel for advice. If it's a complicated hearing, they may have their own counsel, lawyer, so they can ask them questions about procedure. The counsels, there can be up to 3 of them in the room. So the tribunal can have one, the complaints director can have one, and the respondent can have one. There's also a certified court reporter. Their job is to transcribe the hearing word for word, so is their record, to swear witnesses, and they also handle and mark the evidence. So let's continue. We're going to identify what the legal responsibilities of the member are. So section 72(1) says that an investigative person must appear, you can be compelled to testify, and you can be represented by counsel. So you don't have a choice. This is not an optional thing. You must appear. The hearing can be held without you, but in the past, it's not gone well for those folks who haven't showed. You have to testify if you're asked to, and you should or may be represented by counsel. Section 73 says an investigative person can call any person as a witness, including the complainant, and give any person a notice to attend or a notice to attend and produce. So the investigative person in their preparation of their defense can call witnesses that they feel would sway the tribunal to their point of view. Once people are given a notice of attend, even unregulated people, this is a document, it's like a subpoena. People do have to come. The investigative person or their counsel can examine any witness before the hearing tribunal. So if CARTA calls a witness, the counsel or the investigative person can question that witness. So what does the CARTA have to do to fully comply with the Act? Well, the first thing, sections 14.1 and 14.2 require the CARTA counsel to appoint me, a hearings director, and require the hearings director not to participate in any reviews or appeals. Section 15.1 requires the CARTA counsel to appoint no less than 4 members to be used for both hearing tribunals and complaint review committees. We actually have about 10 trained members so that we can ensure that people haven't got any vested interest in your matter. Section 16.1 enables the hearing director to establish a hearing tribunal and a complaint review committee that consists of 2 members of the profession and 1 member of the public. The public members are appointed by the minister and their training is done by government. All right, what do we still have to do as CARTA? When the matter applies to sexual misconduct or sexual abuse, more stringent rules apply to the CARTA. So the hearings director must ensure that 1 member of the hearing panel has the same gender identity as the patient. All members of the hearing tribunal have to be trained on trauma-enforced practice and sexual violence. And gender identity is defined as the personal conception of oneself as male or female. So that's a heavy responsibility. We have to have a panel member the same gender identity. The government lets us tap other colleges on the shoulder because sometimes it might be hard to find a male who thinks they're female, who it gets very complicated. The other thing is 90 days after receiving the referral, a hearing has to be set unless the complaints director says, no, we're not going to pursue this, so dismisses the complaint. The president of CARTA can grant an extension on application by the hearings director. So if you end up getting very sick and you can't participate at the set date, you can apply to me, and if on investigation it's found to be genuine, we would grant an extension. Or the complaints director and the investigative person agree to an extension. So those 2 people get together and feel the hearing would be better served if it was delayed. And last, section 74, the complaints director can call any person as a witness. And I can give those people a notice to attend or a notice to attend and produce, and that means bring a chart or anything that we want to see. Section 74 allows that to occur. And it's important to note that the investigative person also has the same rights. This is a level playing field. So if we look, section 76.1, witnesses can be examined under oath. They can give matters or give evidence on all matters relevant to the hearing. And this is a big one. They are not excused from answering a question because the answer may tend to incriminate the witness. Subject the witness to orders, tend to establish liability in a civil proceeding or prosecution. In other words, everyone who's a witness, be they the complainant, be it a witness, anyone who's on the stand, must answer any question that's relevant to the hearing. They can't say, I don't want to answer this because it would incriminate me. They must answer truthfully. Now, here's the other side of that coin. That answer may not be used or received against the witness in a civil proceeding, a prosecution under this act, or proceedings under any other act. In other words, what you say can't be used against you. So if you admit as a witness to unprofessional conduct, CARTA can't bring that against you. The only time that answer can be used or received against the witness is if there's evidence of perjury. So the balance of not being able to refuse to answer is the answer can't be used against you. So how do we appeal things? We get a decision we don't like. It's available to the member and the college. So either party can appeal in writing within 30 days to the hearings director. The appeal must be scheduled within 90 days if conditions on a suspension, if there are conditions in the decision or suspension on the permit, then the time is shortened to 45 days. It's CARTA Council that conducts the appeal. CARTA Council will listen to an appeal and issue a decision within 90 days. Remember, this is an appeal, so no new information can be added. Only the information that was previously shown in the hearing. So CARTA Council conducts an appeal. They can make new findings. They can go, you know what? Here's what the evidence says about this. We can make a finding. They can quash, confirm, or substitute the decision the hearing tribunal made. They can give the decision or the matter back to the hearing tribunal and say, take a better look at it. Or they can say, well, that tribunal is now contaminated. We want a new hearing by a new tribunal. The investigative person or complaints director can, if they don't like the decision that's issued, 30 days after the council decision is issued, can appeal to the Alberta Court of Appeals. And the Alberta Court of Appeals conducts an appeal. They'll issue a decision. There's no timeline here. They'll take the time it takes to make a decision. They can make any finding that should have been made by council. They can quash, confirm, or substitute council decision. They can send it back to the council with directions. In other words, they don't just say, try again. They'll give specific directions to the council. And they can make award as to costs. Thank you for your time. Very appreciated.